You're listening to the Rainmaking Podcast, hosted by high-stakes headhunter, author, and professional speaker, Scott Love.
You're listening to the Rainmaking Podcast, and my name is Scott Love. Thank you for joining me on the show, and thank you for making this show a success. Today's episode is part of our legal-specific series, where we talk about those issues, trends, and ideas that relate only to the legal profession. And our guest is someone you may have heard of. His name is Tim Corcoran. Our topic title today is Connecting the Dots: Pricing, Practice, and Profits. We're going to dig into that, and I promise this is going to be worth your time. Now, if you're not familiar with Tim, let me tell you a little bit about him. He guides law firm and law department leaders through the profitable disruption of outdated business models. He's a former CEO, a fellow and past trustee of the College of Law Practice Management. He's past president and Hall of Fame member of the Legal Marketing Association. He's an American Lawyer Research Fellow, and he's a frequent facilitator and presenter at lawyer retreats and legal conferences. Also, both Tim and I are speaking at SharePoint's Managing Partner Lab on May 14th and 15th in New York City. All the information for that is on the show notes, as well as Tim's contact information. And the Managing Partner Lab, it's a collaborative 2-day in-person workshop designed exclusively for managing partners and executive directors of law firms. This is a working session built to help senior firm leaders step away from daily demands and focus on the issues that most directly influence firm performance. Again, check the show notes of wherever you hear this podcast, and you'll get more information directly about SharePoint's Managing Partner Lab. As always, this podcast is sponsored by SharePoint Legal Insights, formerly known as Leopard Solutions, turning legal intelligence into opportunity, and also is sponsored by the Rainmaking magazine. Don't lose business to the competition. Read our sister publication to the show and keep business development top of mind. Visit therainmakingmagazine.com today to chart your course to greater rainmaking success. Thanks for listening, and I hope you get some valuable ideas from my conversation with Tim today. Hey, this is Scott Love with the Rainmaking Podcast. Our special guest today is Tim Corcoran, and we're talking about connecting the dots: pricing, practice management, and profit. Tim, thanks for joining me on the show today.
It's my pleasure to be here, Scott.
This is great. I'm really excited about hearing your perspective on pricing, practice management, and profit. And let me ask you this: among those three things, and the person that's listening to this is either a law firm leader or a partner in a law firm, which of those do you think they should focus on in terms of generating business, earning trust, and doing the work for their clients?
Well, of course, they're all connected. That's sort of the point. But I would say that profit should be the focus. And I don't say that in a way that connotes that they should be greedy and always trying to make the most money. What I mean is, if you understand your service offering and you understand your client, what their needs are, what their propensity to buy is, then ultimately everything you do is designed to serve that need and to do so profitably. But the whole profession has been focused for several generations on the inputs, the productivity, the workflow metrics, rather than the outcomes. Despite the fact that we promote from the top of the trees every year, profits per partner, that's really not the goal. That's an outcome that we don't think about. So I think if they shift their mindset to focusing on profit, everything else becomes a lot easier to understand how it ties together.
Well, do you think a partner, if they focus on profit, do they feel like they're not serving their clients? Do you feel that's going to be contrary to their focus on client service?
Well, I think it actually makes it less adversarial. The entire business model is adversarial, right? I price based on how long it's been since I was in law school, not based on the value of my advice. I must act as if everything's bespoke, and yet I'll also at the same time say, look, I'm band one in this famous ranking showing that I'm the best in the world, but I have to treat this as if I've never done it before because I bill by the hour. And so the whole model currently is adversarial because we're focused on the inputs, the production. But if we're focused on the profits, then I can say, it doesn't matter how many hours I charge. If you find value in what I say and what I do, my decades of experience, then I'll charge you a legitimate fee based on, how important this is to you and my knowledge. And we don't have to count how many hours it took me, right? And so I think it actually creates a better opportunity to serve client needs.
So let me ask you for an example. You don't have to mention the name of the firm or the individual you've worked with, but tell me about an organization, tell me about a law firm that has just nailed it. They've done all these things that you're talking about. Let's kind of start with that. What does that ideal template look like?
So I think one of the first things to note is that very few law firms do anything collectively well, right? Law firms are really an exercise in how to have silos come together with the same logo on the business card, but we're operating like independent businesses. So I don't believe that there is a law firm anywhere that's doing all of this well. There are absolutely pockets of innovation where they really truly get it. And sometimes they get it only because the clients have demanded that they change their behavior. And of course, if you're at risk of losing the client, you'll wake up. But if the client's not complaining, we keep doing what we do. So that's the caveat is even if I were to name names, I couldn't name an entire firm. They all do it in a sort of haphazard fashion. But what I have seen is that where there is a client demand or there is an opportunity to differentiate through pricing or service delivery, and they see the success of that, then lawyers will embrace this again and again. But typically, we do innovation at the point of a spear. The client has to either demand it or threaten to leave, or we get signals such as RFPs, outside counsel guidelines. We're asked to pitch for the work we've always had from this client. And so the signal is, hey, we're starting to really pay attention to this, and maybe we're going to start chiseling on price, and you're going to have to compete for the work now. And so those signs, even if it's not explicit, indicate that you should try something different, try to be innovative, because otherwise, you may be at risk.
Let me go back to something you said, and I appreciate what you just shared also. You talked about where there is some sort of differentiation, such as in pricing or in delivery. Um, Sometimes I think in concept, I totally agree with you. I think that firms need to show how they're different and not just that, how they're distinct. In fact, one thing I've done when I meet with law firm leaders, I'll ask them this: what can you say about your firm that nobody else can say about their firm? And you would have thought I've asked them for a moment of silence, but I'm trying to pull through something that is totally rare that starts a conversation. Because when something is rare, I'm making a pitch of a firm to a prospective candidate or group leader to join that firm. If I have let me tell you something that's different about this firm that no other firm is like. Now I've got their attention. Give me examples. How can a firm show that they're different? What are some examples of differentiation and even distinction that you've seen, Tim?
Well, we could talk for hours about the various ways you can market your services differently and how you can demonstrate expertise. But I think those are helpful. But the secret magic sauce I found when I launched the very first legal project management practice years ago, before it was vogue, but it was something I had learned in my business career. And so I traveled the world teaching lawyers how to do project management even before it became LPM. We had to give it the legal name to make sure they understood it was special for lawyers. But here's what I learned. While they perceived project management and process improvement to be some way to commoditize the work so it can be cheapened and pay less for it, what it really presented was an opportunity to differentiate that I know how to do this work. By way of example, if a client says, I want a budget for this matter, the lawyers say always, in whatever language of the country I'm in, some version of, well, it depends. Well, of course it depends, right? That's the whole point, is I'm asking you for a budget to help me understand the scope of this. And so the answer for an amateur is it depends. The answer from a professional is it depends. And here's what it depends on. And so if you've actually broken down how you do this work, you flow chart it out and you understand the various pieces and what pieces are fairly routine, what pieces have some variability, what pieces of this work have significant volatility, what stages you can predict right now with some certainty versus what stages are too far away to predict because we don't have enough in our fact pattern to give any advice. What you're doing is you're speaking the client's language, because for them, a budget is an exercise in probabilities. Every quarter, sometimes every month, they've got to sit with their CFO and explain their upcoming spend. And managing expectations is critically important in most businesses. And so no one wants to be the person that says, I can't control my supply chain. My vendors are rogues. So I told you what the budget was last quarter, and it turns out to be 2x that. Now, we'll have to pay that because they're a supplier and they delivered services that we needed. But the CFO wants to know in advance, at least give me some heads up, because you don't understand how much scrambling we have to do to cover that. But if you had just told me, right? And so lawyers think the answer is reduce the price. And it's not. It's manage the expectations. So if a client says, how much does it cost? I would love to get out a yellow legal pad and a marker and say, well, let me walk you through it. So first we have to do, I don't know, it's litigation, an early case assessment. And based on that, we understand the fact pattern. We understand, is there a smoking gun? Is there not? Do we have facts on our side? And that will define whether we're going to defend or settle. And if we're going to defend, well, we have to go in this direction. We've got to do some discovery, and we're going to learn more. Now, we don't know how many depositions we'll take. We don't know what we'll learn in discovery. So I can't predict the full stream of how this work goes. But I can tell you, if we decide at that point we're not going to defend, we're going to settle, well, this whole other path of iterative conversations back and forth, but it's far less expensive and takes far less time typically than if we're going to, have a multi-year case, defending. And so it's like that. So whether it's, early case assessment or due diligence in a transaction, we lay out, here are the steps, and then we talk about which of these steps has some variability and volatility, which is pretty routine. And through that process, whether we've set a number at all, we're conveying that I've done this before, right? We can listen to the 22-year-old journalism grad that lives in London and tells everyone they've researched all their clients and we've decided who's band one. Or you can listen to the lawyers talk about how they do the work, and it becomes crystal clear. And so what that process does is it conveys expertise, and it also helps manage expectations, because if they come in with a number and that number is completely out of the scale for what they're asking for, we can either tell them they're crazy and, they're going to have to find someone else, or they're going to have to change their expectations, or they're going to have to accept far more risk, which is the client's choice, right? So anyway, the point is, I think if you focus on how to do the work differently, then you can manage expectations, you can budget, you can improve predictability, minimize the surprise that is the bane of law firm invoices in every corporation, and differentiate, because everyone else says we're the best, we're good looking, we're tall, we're really nice, we're a big firm with a small firm feel, so we're different. And yet we all say that, and we say it on a website that has skylines and we have scales of justice, and we say, but we're different. So I think the true differentiation comes from showing how good you are. And that means you have to understand how you deliver the work.
Absolutely right. And I think that does tie it all together, as you said. Something I heard from a very successful partner, and I can't remember who it was. I don't know if it was a guest that we had on the show, but somebody said this. They said, when you're getting work, make sure the CFO is involved in the decision. What do you think about that concept?
Absolutely. I spent time talking at the various associations for procurement and legal operations, and I was doing that before they existed. And what I was trying to convey was the legal department is a business function, right? It's not a little law firm inside a business. Ultimately, what the business people want, and which is where I grew up, right? With multiple times the Department of No, always telling us, no, we can't do something because they saw risk as binary. Don't do it. There might be risk. Can't do this contract. There might be risk. And what we were saying, we're trying to launch a product. We're trying to get something out the door. We're trying to beat the competition. We're trying to become the reference brand for this space. And we were always trying to get what I call business velocity. And so the legal function, its job is to manage the organization's risk while also helping to manage business velocity. And when you have a lawyer who sees it as an academic exercise and then hires outside counsel who sees it as an opportunity to write a 90-page memo, when what I really want to know is, can we proceed with this? And if there's going to be risk, help me understand what the various avenues are to overcome that risk or mitigate that risk. And also there's a budget at all times, always. And so if you're understanding the whole supply chain in the business before the law department gets involved, then you absolutely recognize the importance of the CFO. And you should also recognize the business people behind the scenes, because they have the build versus buy calculus going on all the time. So they're the ones who ultimately are deciding whether or not we proceed. And I think that's a missed opportunity.
So let's say somebody's hearing all this and there's a practice group leader and he's nodding his head and he's saying to himself, or she's saying to herself, Tim, I totally agree with you. in terms of the pricing and the practice management, but my hands are tied. I want to have a conversation with my leadership to get some help, not from them in terms of changing the pricing, maybe making it more flexible or other changes we can make. But what do you think that frustrated person should do in terms of having a tough but real conversation with their leadership about these issues?
Well, I think the challenge in many law firms is that we believe we're managing, but we're actually being pretty lazy. So when we say we've declared a 6.5% across the board price increase or rate increase, that is astoundingly naive. This is a multi-line business. We're operating across geographies. We have different client segments. We're operating in economies that are in fundamentally different ends of the business cycle. And we have commodity services and we have leading edge services that no one else can touch. And to think that the revenue opportunity and the propensity to buy in all of those markets at all at the same time has the exact same likelihood of spending 6.5% more next year is just astoundingly myopic. And so I'd rather come at the conversation with data. So if I am looking at my realization rates, but what time I'm recording versus what I'm invoicing, right? Billing realization, or what I'm invoicing versus what I'm collecting. So collection realization, or the combination of those two. And I find that there are certain services that we offer that have low realization, right? In particular, if they also come with outside counsel guidelines and we have to pitch for the work, right? The client is sending a clear signal. You're charging a rate that you think is, tied to the value, but we can find this offering for far less. Whereas practices with services that are, high realization, sometimes even more than 100% with success fees, well, those, rather than say 6.5%, like that's great. What they should be saying is maybe it should be 16.5%, right? If we're at the top of the market and no one can touch us and the value is immense, why do we link it to how many years I've been out of law school plus some cost of living increase, right? So the nuance there is we have to know the data. So if I'm going to go to firm leadership and say, I need to make some adjustments, I'm okay with a 6.5% price increase for certain things, but in these other areas, we're going to explore some ways to price more competitively, possibly flat fees, fixed fees, collars. And maybe as we do that, we're going to re-engineer some of the ways we do that work because efficiency now will work in our favor. And for these other services that we offer that we have high realization, we're probably going to actually make our standard rate higher. That's the kind of conversation I'd love to have with a firm leader rather than I'm trying to, look at my big book. I have clout. Let me, negotiate my own terms. I'd rather say, no, I have data. So let's do it that way.
That's interesting. How does benchmarking come into play in these things that we're talking about?
Well, I think it's the most common way to compare firm performance, but looking at a dissimilar firm with a dissimilar practice mix and a dissimilar geographic footprint, offering dissimilar services to dissimilar clients and saying, well, let's do it like them is no better than an AmLaw 200 firm saying we're exactly like the AmLaw 10. So let's copy what they do, right? So benchmarking is helpful to a point. But what we're really talking about with benchmarking, I think, is part of the challenge that underlies everything we're talking about, and that is risk aversion, right? We don't innovate in law firms, not because lawyers are not innovative. They're extraordinarily innovative. The level of intellect I see in the creative solutions and the business and the litigation side, crazy good people, smart people. But when it comes to their own business, they are risk averse. If they haven't seen it work, they want to know if 10 other firms that they respect or despise, but value that they're like us, they want to benchmark and they want to baseline against those other firms. And that's really about, I don't want to be first. I want to be first to be second maybe, but I don't want to be first, right? The good news is, if you're still thinking about it, there's no chance of you being first anymore, right? Innovation has passed you by if you're still thinking, should we try something different? So great, now you can go with the herd. It's a lot easier now than it was 15 years ago when doing something like a flat fee or embracing process improvement to reduce the amount of hours you spend delivering something to meet a client's demands, like that was seen as career suicide. Why would you do that? But now innovation, as I said, in pockets everywhere is happening and it's proving that it's very lucrative. So I think the benchmarking and baselining is a bit of a distraction. But if we find comfort in numbers, there's plenty of numbers to point to.
Well, thank you, Tim, for that. And thank you for being here. And I'm going to talk more about the Managing Partner Lab in a second. But in terms of 3 action steps somebody can take to implement some of these ideas, what would those be? If they can really get started thinking about these things, what would be 3 action steps you'd recommend, Tim?
So I think a good look at the data would help. So most firms of some size have either a finance team or a business development team that has access to the firm financials. And I would try to understand, what are we getting paid to do? And so that's a combination of your billing realization, your collection realization. It's the outside counsel guidelines. It's what's on an RFP. Like, understand the services that you offer. And many practices are immense. So we can do it at the matter type level, or sometimes we can do it at the task level, depending. We have the data, and understand where you're getting price pressure, because price sensitivity is not universal. A client that is going to push back on rates in one area might be delighted to spend 2x your current rate now to solve a different problem. And so I'd try to understand where that is. And then, once we can isolate those differences, we can act differently.
Hmm.
The second thing I'd look at is understanding where your incentives lie. So if you want to grow your practice, but you're in a firm that has incentives that are misaligned. So if I hunt in a pack, if I bring someone else into my matter, and at year end, I have to split that credit and it costs me money, then I won't say it out loud necessarily, but I'm not going to be as cooperative as if I'm with a firm that values that. And so the more practices working with a client, the more compensation is available to those who have made it so, because that creates a pretty significant switching cost, right? If one of us were to leave, that client in total won't leave because they're working with multiple parties here. And so understand where the incentives lie. And then I spend most of my time unwinding misaligned incentives. And I can tell you that it's not something any individual lawyer or practice group leader can solve on their own. But first of all, truly understanding where they're misaligned can be helpful.
We could have a whole conversation just on that, right?
We could for hours and hours.
That'll be our next show. And what's point number 3, Tim?
The third one is, if you want to cross-sell and you want to either bring in colleagues to help do work with your client, or you have services to offer to other clients of the firm, but nobody's bringing you in, don't think about it as an exercise in finding opportunities to have coffee. Think about it as something you can engineer. So in your client's supply chain, if, I don't know, make it up, you're doing commercial real estate and you do the leases for big box retailers, right? Well, before you get involved, someone is doing some land use work. Someone is doing zoning and permitting. Someone might be doing an environmental cleanup. Someone might be doing financing, right? And after you've done that work, somewhere down the line, that business may have lease renewals. It may have tax issues. It may have, slip and fall injuries. It may have all sorts of. So where are you in that supply chain? And what are you doing to make sure that the services that they buy later on for the work stream you're in, you're setting up your colleagues to make sure that the client knows your firm has those capabilities to do that work, even if it's not contiguous. So it's not the next thing on the supply chain for the client to do. And the same thing upstream. Your colleagues who are doing some work that could benefit you, but it's a couple stages up the supply chain, engineer that cross-sell. Sit down with them and say, what can we offer at that point early on? Can it be an assessment or an audit of how they're doing things, or a risk management profile to help them? So by the time they're ready to hire a law firm to do what we do, they've already been talking to us, right? And we're in position. So it's an engineered cross-sell. To me, that's way more valuable than trying to spend Saturday mornings memorizing your intranet so you know what everyone else does.
This is great, Tim. I'm really glad we had you on the show. And tell our listeners about your offerings. What do you do? What do you have that you'd like everybody to know about? And we'll put all of your contact information on the show notes so people can reach out to you directly.
Yeah, so I run my own consulting practice based out of Charlottesville, Virginia, after 22 years in Princeton, New Jersey. I operate all over the world, but my focus these days is on boardroom topics such as partner incentives, profitability, pricing, practice management. So it's really, how does a boardroom understand what are the KPIs we should be looking at versus what have we been looking at? And are we rewarding partners for doing the right things, or are we rewarding partners for doing what serves their needs but hurts the firm's interest? So those are the things I do. I speak a lot. I run workshops. I'm at partner retreats. But ultimately, my job is to help them embrace business ideas that they can adapt to their own law firm. And all of these lessons I learned in my 20 years in the corporate space, where law firms and law departments were my clients. So I know the space pretty well. And I also know what works and what doesn't.
Absolutely, Tim. Thank you for being on the Rainmaking Podcast today. And for everybody else listening, both Tim and I will be at the Managing Partners Roundtable, sponsored by SurePoint Solutions. That's going to be May 14th and 15th in New York City. Tim's topics are going to be firm financial performance, what top firms do differently, and also a workshop on performance benchmarking and pricing diagnostics. And for everybody listening, go to the show notes. You'll be able to register and get more information about that Managing Partner Lab directly. Tim, thank you for being here on the show. I'd love to have you back on in the future, and I look forward to seeing you at the Managing Partner Lab.
It's my pleasure. Thanks for having me.
Thank you for listening to the Rainmaking Podcast. For more information about our recruiting services for international law firms, visit our website at attorneysearchgroup.com. To inquire about having Scott speak at your next convention, conference, sales meeting, or executive retreat, visit therainmakingpodcast.com.